Usually when we think about the law,
Yeah.
there's this like expectation of drama, right? Like a clear sense of right and wrong.
Oh, absolutely. Someone breached a contract or, someone committed a crime.
Exactly. Someone was wronged. We inherently look for the villain and the victim.
Right. We look for the moral center of the story, like who is to blame and how should they pay.
But then you open up a textbook on civil procedure.
It's just dry.
So dry. Suddenly all that drama is just gone. The moral compass is completely removed from the equation.
Yeah, it really doesn't care who's a good person or a bad person.
Not at all. It is the absolute definition of a mechanical system. A purely functional, invisible architecture.
That's a great way to put it.
And we've got a massive stack of source material today. Specifically, these study guides and strategy scripts for the multi-state bar examination.
The MBE.
Right, the MBE. And they're focusing entirely on civil procedure. So our mission for you today, for this deep dive, is to totally demystify the subject.
Which is much needed, honestly.
Right. We want to take what looks like an incredibly overwhelming, dry list of rules and transform it into a predictable, logical workflow.
Because that is exactly what it is. It's a workflow.
Yeah.
If you understand the flow, the rules stop feeling like these arbitrary hurdles designed to torture law students.
Which they definitely feel like at first.
Oh, 100%.
Yeah.
But they start looking like a very precise machine with a specific operating manual.
Okay, let's unpack this, because the sources highlight a really surprising insight right out of the gate.
Mm-hmm.
Unlike criminal law or torts, civil procedure is not about moral blame. It only cares about the mechanics of the lawsuit itself.
Right. Is it in the right court?
Against the right parties?
At the exact right time.
Yeah. And that's the fundamental mindset shift you have to make before you read a single rule.
You really do. To understand civil procedure, you have to fundamentally change how you look at a lawsuit.
Okay, so how should we look at it?
Well, you cannot look at it as a story of human conflict. You have to view it as a timeline.
A timeline.
Yeah. The very first rule of tackling any civil procedure issue, especially on a tricky exam like the MBE, is to stop and ask, where are we in the life of the case?
Right, because the text lays out this timeline incredibly clearly. It maps out 7 distinct stages.
7 stages, yeah.
Stage 1 is before filing, like figuring out if you even have a legal claim and who the parties are.
Right. And then stage 2 is filing in service, getting the complaint on the record and officially notifying the defendant.
Which brings us to stage 3, right? Jurisdiction and venue.
Exactly. This is about figuring out if you are in the correct court, both geographically and legally.
Okay.
And once you're situated there, you hit stage 4, which is pleadings and motions.
The initial back and forth paper war.
Yeah, where claims are stated and those early defenses get raised.
And then we hit stage 5, which is discovery and pretrial management.
Discovery.
Which honestly just sounds like an absolute nightmare of endless paperwork, exchanging documents, taking depositions.
I mean, it is notoriously grueling.
Right.
But procedurally, it's the engine of the lawsuit.
Right.
It's where you figure out exactly what evidence actually exists in the real world.
Which leads directly to stage 6.
It's trial and judgment.
The actual courtroom showdown.
Yep. And finally, stage 7 is post-trial motions, preclusion, and appeal. Basically what happens after the gavel bangs.
So it's like playing a highly structured video game.
Oh, I like that analogy.
Right. Like, you can't use a level 6 weapon in a level 1 zone.
No, you can't.
If the case has just been filed, like, if you are barely out of the starting gate, you can't start applying trial standards to resolve a dispute.
Right. You literally don't have access to those tools yet.
That makes total sense.
And if we connect this to the bigger picture, this timeline dictates everything. It dictates what rules are even available for you to use at any given moment.
Give me an example of that.
Okay, so if you're looking at a question about stage 5.
Discovery.
Right. The rules that matter are going to turn on the mechanics of information gathering, like the scope of the request, privilege, proportionality, timing.
You're simply asking, am I allowed to see these emails?
Exactly. But if the timeline shifts to stage 6, which is trial, suddenly the rules are entirely different.
Right.
Now you're dealing with jury rights, verdicts, and judgments as a matter of law. A pleading standard from stage 4 is completely useless to you during a trial.
So the timeline really is everything.
It's everything.
Well, let's dive into the mechanics of getting this timeline started, getting into the court in the first place.
The gateways.
Yeah, the sources spend a massive amount of time on this, getting through the gateways of court power and location. The text identifies 5 distinct gateways here,
I have them, yeah.
and it seems like the MBE loves to mix them up to trap you.
Oh, what's fascinating here is how often test takers merge these concepts together.
Really?
Constantly. You have to keep these 5 boxes totally separate in your mind.
Okay, so walk us through them.
First, you have subject matter jurisdiction, or SMJ.
SMJ, got it.
This asks, does the court have constitutional power over this specific type of case?
Right.
Federal courts are courts of limited jurisdiction. They can't just hear a case because it's interesting or, involves a lot of money.
They need a specific legal basis.
Exactly. Like a federal question being debated or diversity of citizenship between the parties.
So that's the constitutional authority. The court is legally allowed to look at, say, a civil rights claim or a major interstate dispute.
Yes. But having power over the claim doesn't mean they have power over the specific person being sued.
Wait.
Yeah, that brings us to the second gateway.
Personal jurisdiction, right? PJ.
Right. PJ asks, does the court have power over this specific defendant? Can this particular person or company be forced to litigate in this specific state?
Okay, hold on. I really want to make sure I understand this because it sounds crazy.
Go for it.
A federal court could have the absolute constitutional power to hear a massive civil rights violation.
That's the subject matter jurisdiction.
Right. But that exact same court could still completely lack the power to force the actual defendant to show up.
Precisely. Because they're evaluating 2 entirely different relationships.
Oh, I see.
Subject matter jurisdiction evaluates the relationship between the court and the legal claim. Personal jurisdiction evaluates the relationship between the court and the defendant.
Okay, so it's like a New York bouncer trying to throw you out of a club in Chicago.
Okay, I'm listening.
Like, sure, they have the official job title of bouncer, they have the subject matter jurisdiction to bounce people.
Right.
But they're in the wrong state. They have absolutely 0 geographical authority, 0 personal jurisdiction to put their hands on you in Illinois.
That illustrates the mechanical separation perfectly.
Right.
You need to unlock both of those gates independently.
Wow. Okay, so what's the third gateway?
The third is venue. This focuses on statutory convenience.
Convenience.
Yeah. Even if the court has power over the case and power over the defendant, is this specific geographic district the proper place? Like, where did the defendants actually live? Where did the events giving rise to the lawsuit actually happen?
See, venue feels like it overlaps a lot with personal jurisdiction.
They often point to the same location, but they are legally distinct.
How so?
Well, personal jurisdiction is about constitutional fairness. Like, can we drag you here at all? Venue is about administrative sorting. Which specific courthouse building makes the most sense?
Okay, that makes sense. And the fourth gateway?
Fourth is service of process. Did the defendant receive a legally sufficient summons and proper notice?
Because due process demands a defendant actually knows they are being sued, right? So they have a fair chance to be heard.
Exactly. You can't just whisper it to a wall. You have to serve them.
Right. And then there's the fifth gateway, which honestly always sounds incredibly intimidating when you read the study guides.
Ah, you mean the Erie doctrine.
It's the Erie doctrine.
Erie is a fascinating mechanism. It asks a very specific question for federal courts sitting in diversity jurisdiction.
Which is?
Should the court apply federal law or state law?
Okay.
The general rule of thumb is that a federal court applies federal procedural rules, but state substantive law.
Let's translate that. Why does the Erie doctrine even exist? Like, what's the mechanism doing?
It exists to prevent forum shopping.
Forum shopping.
Yeah. Imagine you are in Pennsylvania and you get into a car accident. You want to sue, but Pennsylvania state law has a very strict limit on how much money you can recover for negligence.
Ouch. Okay.
However, you realize you can file the lawsuit in the federal courthouse right across the street.
Oh, I see where this is going.
Yeah, if the federal court had its own more generous substantive rules for negligence, every single plaintiff would just cross the street to the federal building to get a bigger payout.
Which is totally unfair.
Exactly. Erie stops that. It says to the federal judge, hey, you can use your own federal rules for how to file papers and manage the trial timeline.
Because that's procedure.
Right. But when it comes to the actual substance of the negligence claim, you must apply Pennsylvania state law exactly as the state court across the street would.
That makes total sense. It keeps the playing field level regardless of which building you walk into. And speaking of which building you walk into, the sources highlight a massive day one trap regarding subject matter jurisdiction. Specifically, Diversity jurisdiction.
Oh, the diversity trap.
Yeah.
Yes. To get into federal court based on diversity, you need complete diversity.
Complete diversity.
That means no plaintiff can share state citizenship with any defendant.
Right.
If there are 50 plaintiffs from New York and just one single defendant from New York, complete diversity is destroyed. The federal gate slams shut.
And the trap is how the MBE defines citizenship for an individual, right?
Yeah, the exam will try to trick you by talking about where someone lives or rents an apartment.
But for diversity purposes, citizenship means domicile.
Domicile.
Yeah.
Exactly. And domicile requires two very specific things. Physical presence in the state plus the intent to remain there indefinitely.
So residence alone is mathematically insufficient.
It really is. You can reside in a dorm room in Massachusetts for 4 years of college, but if your intent is to return to your home in Ohio after graduation,
Your domicile, your citizenship for this gateway remains Ohio the entire time.
you nailed it.
Okay, so we've unlocked the doors with our 5 gateways, but just because you have the keys doesn't mean you can walk in whenever you want.
No, it doesn't.
The timeline we established earlier is actively ticking. It's not enough to simply understand the separate gateways. You have to defend them before time runs out.
Right. And this brings us to a critical structural distinction in civil procedure.
Waivable versus non-waivable defenses.
Yes. The timing rules here are drastically different, and they are dictated entirely by what the rule is actually trying to protect.
Let's start with the big one, subject matter jurisdiction.
Subject matter jurisdiction is special. It is never waived.
Never.
Never. Because it goes to the very constitutional power of the federal court to exist and hear the case, it cannot be created by accident.
Right.
And it cannot be created by agreement. Anyone can raise the fact that the court lacks subject matter jurisdiction at any time.
So a defendant can raise it?
Yep.
A plaintiff can raise it?
Yes. The judge can even raise it on their own. You could be 3 years into a case, standing in front of the appellate court, and raise it for the very first time.
Wow.
If the court lacks power over the case type, the entire case is dismissed, period.
Okay, so SMJ is practically bulletproof. But the other gateways, personal jurisdiction, venue,
I thought they were completely different beasts.
they are use it or lose it defenses.
Totally. This
Yeah.
is governed by the infamous Rule 12 waiver trap.
And here's where it gets really interesting.
Yeah.
Because the text points out the absurdity and really the danger of this Rule 12 trap.
It's a huge pitfall.
Let's say a plaintiff sues a defendant. The defendant gets the complaint, reads it, and thinks, this claim is absolute garbage. I didn't break any law.
Right.
So the defendant files a Rule 12 motion to dismiss, complaining that the plaintiff failed to state a valid legal claim.
Normal so far.
But in their rush to argue the merits of the case, the defendant completely forgets to mention that the court lacks personal jurisdiction over them. Like the New York bouncer is trying to grab them in Chicago and they forget to point that out.
It's too late. They waive the defense permanently.
That's just wild to me. If you're listening to this and thinking, wait, I can lose my entire defense against being dragged across the country just because I forgot to check a venue box on day 1.
Yes?
Yes,
Yeah.
that is the exact trap the MBE is going to lay for you.
Personal jurisdiction, improper venue, and defective service must be raised in your very first Rule 12 response.
Whether that's a pre-answer motion or your official answer to the complaint itself.
Exactly. If you speak to the court and you leave those specific logistical defenses out, the law assumes you are consenting to the court's power and location.
Hey, Judge, this guy's legal claim is terrible. Also, wait, I shouldn't even be in this state?
And the judge just says, sorry, you already argued the claim. You're stuck here.
It's brutal.
It is, but if we look at the underlying logic, it actually makes sense.
Really? How?
Well, failure to state a claim is a flexible defense. It's about the substance of the lawsuit. That can be raised much later, even at trial.
Because if there's no valid law being broken, there's no case to decide.
Right. But the gateway defenses, where are we litigating and do we have power over me? Those are threshold logistical issues.
Okay, I see.
The court system demands efficiency. We cannot spend 2 years litigating the nuances of a contract only for you to suddenly mention, oh, by the way, venue is improper.
Right.
You have to raise the logistical objections immediately in your very first breath or forever hold your peace.
Okay, so once you survive that initial ambush, you navigate the gateways and avoid the Rule 12 waiver traps, you are officially in the system.
You're in.
But as the timeline moves forward and evidence is developed, the rules of the game shift dramatically.
Yes, this is the concept of procedural posture.
Procedural posture.
Yeah, the exact same set of facts will produce entirely different results depending on the posture of the case. The sources detail 4 major procedural motions. And understanding how the burden of proof shifts between them is absolutely crucial. Think of the judge's power to dismiss a case shrinking as time goes on.
Let's walk through that shrinking power. First up, the 12b6 motion to dismiss.
Right.
This happens very early, right at the pleading stage, before anyone has swapped a single email in discovery.
Exactly. At this early stage, the court does not look at any evidence.
Because there isn't any yet.
Right. The court does not decide who is telling the truth. The court simply looks at the plaintiff's complaint and assumes every single factual allegation written in that document is 100% true.
Wait, really? Why does the judge do that?
Because the judge is acting as a bouncer for bad legal theories.
Okay, give me an example.
If you sue someone, claiming they looked at you funny in the grocery store, the judge assumes it's true that they look at you funny.
Okay.
But the judge throws the case out because looking at someone funny isn't a recognized legal wrong.
I see.
The motion asks, assuming your story is true, does the law provide a remedy? If not, the case is dismissed before we waste time and money on discovery.
So at 12b6, we assume the facts are true.
Yes.
But what happens later? After we've survived that motion, we've done months of discovery, and we actually have receipts.
That brings us to the second motion, summary judgment.
Summary judgment.
Now, we've developed the evidence. We have emails, depositions, signed contracts. The court looks at all of this actual evidence and asks, is there a genuine dispute of material fact?
Okay, let's translate that legal jargon. What is a genuine dispute of material fact?
It asks if there is actually a factual fight that requires a jury to resolve. At summary judgment, the judge is a bouncer for empty evidence.
Empty evidence.
Yeah. If you sue claiming breach of contract, but discovery reveals there never was a contract, the judge dismisses the case. There's no need for a trial. All the evidence points one way.
But if there is a conflict in the evidence...
Then the judge's hands are tied. Oh, yeah. If the plaintiff has a witness who says the traffic light was red, and the defendant has a witness who says the light was green, that is a genuine dispute of a material fact.
Because both sides have proof.
Exactly. And the judge cannot weigh the credibility of those witnesses.
Why not?
The system is designed to protect the jury's absolute right to decide who is lying and who is telling the truth. The judge must deny summary judgment and send it straight to trial.
So 12b6 is about testing the legal theory of the complaint. Summary judgment is about testing the existence of evidence before trial.
Right.
What happens during the actual trial?
That's the third motion. Judgment as a matter of law, or JMOA.
JMOL.
This happens in the middle of the trial, after one side has presented their case directly to the jury.
Okay.
The judge looks at what actually happened in the courtroom and asks, based on the evidence presented at trial, would a reasonable jury have a legally sufficient basis to find for that party?
Meaning, did the evidence completely collapse on the stand?
Precisely. You might have survived summary judgment because you promised you had a star witness who saw the red light.
Right.
But when that witness got on the stand during trial, they admitted they were wearing a blindfold.
Oh, wow.
The evidence was a total dud. If the plaintiff's case is so incredibly weak that no reasonable jury could possibly rule in their favor, the judge steps in, takes the case away from the jury, and decides it themselves.
Wow. And the fourth and final motion happens after the jury comes back with a decision, right? The motion for a new trial.
Right. This is the ultimate safety valve. It asks if the verdict simply cannot fairly stand.
Like what?
Maybe the jury's decision was wildly against the clear weight of the evidence, or the damages they awarded were absurdly excessive.
Or a lawyer committed severe misconduct during the trial.
Exactly. The judge isn't saying the other side wins outright. The judge is just saying something went procedurally wrong here. We have to throw this result out and do the whole trial over again.
So if I'm looking at a problem, and the scenario describes a case that is at the very beginning, the pleading stage, fading a 12b6 motion,
Yeah.
and one of the multiple choice answers mentions weighing the trial evidence or asking what a reasonable jury would do, I can just immediately cross that out.
Absolutely. That is the biggest day one trap.
Fixing the standards.
Do not mix motion standards.
Right.
You cannot apply summary judgment evidence standards to a motion to dismiss.
Right.
And you cannot apply pleading standards to a judgment as a matter of law mid-trial. The procedural posture controls the standard. You must match the stage of the timeline to the standard being applied.
We've covered a massive amount of ground today. We've shifted our mindset from moral blame to a ticking timeline.
We have.
We've separated the 5 gateways of jurisdiction and venue, we've navigated the Rule 12 waiver traps, and we've seen how the standards shift based on procedural posture.
That's a lot, I know.
It is. So what does this all mean? How do we bring this all together into a practical strategy for the listener?
Well, the sources synthesize all of this into a brilliant, repeatable, 6-step attack method for any civil procedure problem.
Okay, let's hear it.
Step 1. Identify the case stage. Are we at filing, discovery, or trial?
You're right, the timeline.
Step 2. Identify the court. Are we in federal or state court? And if federal, why?
Subject matter jurisdiction.
Step 3. Identify the procedural issue. Are we arguing about geographical venue, or are we arguing about a pleading standard?
Got it.
Step 4. Ask if the issue is waivable. Remember, subject matter jurisdiction is never waived. Personal jurisdiction absolutely is.
Use it or lose it.
Step 5. Apply the timing rule. Was the defense raised in the very first Rule 12 response? Did the clock run out?
Did you miss the deadline?
Exactly. And finally, Step 6. Match the answer to the procedural posture. Do not choose an answer applying a trial rule at the pleading stage.
It's a perfect checklist. Ultimately, what this deep dive reveals is that civil procedure heavily punishes vague reading. You can't just look at a lawsuit as one big, messy blob of human conflict. You have to be meticulous. You have to track exactly who is suing whom, what the specific legal claim is, and exactly where the clock has stopped on the timeline.
And if you do that, the invisible architecture becomes visible.
Yeah.
And the workflow finally makes sense.
Yeah.
But, if we step back from the mechanics for just a moment, it does leave us with a rather profound question to consider.
Oh, what's that?
Think about the harshness of that Rule 12 waiver trap we discussed.
Right.
If a single missed deadline or a forgotten paragraph in a defense motion can permanently force a defendant to litigate in a fundamentally unfair venue, completely lacking personal jurisdiction,
Yeah.
we really have to ask ourselves, does our highly structured procedural system sometimes prioritize the administrative efficiency of the courts over actual substantive justice?
That is a heavy thought to leave on. A system designed to be perfectly mechanical might just grind up a few people in the gears along the way simply because they missed a deadline.
It's something to think about.
It really is. Thank you for joining us on this duck dive. Keep exploring, keep questioning, and remember, sometimes the most important part of the story isn't who is morally right, but whether they filed the exact right paperwork at the exact right time. Catch you on the next one.